Saturday, March 16th at 7:23 in the evening, my sister pressed my face into my own birthday cake while the waiter was still standing at the end of the table with the check presenter in his hand. The reservation at Millstone Kitchen in downtown Minneapolis was under my name. I had called it in a week earlier, confirmed it that morning, and handed over my credit card when we sat down. 12 people were at the table. Our parents, 2 cousins, an aunt, and 2 of my grandmother's longtime friends from her church. I was turning 29. I remember that detail clearly because I had thought 29 was old enough to host a quiet dinner without being managed. The cake had just been set down. Vanilla with buttercream frosting and a hard sugar decoration shaped like a branch of lilac across the top. Someone had asked for a photo before we cut it. My cousin Daniel lifted his phone. Laura stood behind me, her hands resting lightly on my shoulders. There was laughter. I was looking toward the camera when her hands pushed down. It was quick and deliberate. My left eye hit first. I felt frosting pack into the socket and something rigid scrape across the surface. There was a sound, silverware against plates, a chair leg dragged too fast. My vision went white and then blurred. I heard Daniel say my name. I heard one of my grandmother's friends say Laura in a tone that wasn't amused. When I lifted my head, icing slid down my cheek and onto the collar of my blouse. My left eye burned sharply, not like embarrassment, not like a joke gone wrong. I couldn't focus on the faces across from me. The waiter stepped back. The check presenter was still in his hand. No one had agreed to that kind of joke. No one had counted down. I had not been bracing for anything. The dinner was in my name. The bill was mine. The room was public. And I was the only person at that table who did not seem to know what was about to happen. Daniel reached for a napkin and then stopped, as if unsure whether touching my face would make it worse. I stood up because sitting there felt like consenting to something I hadn't chosen. The chair legs scraped against the tile. I excused myself, though I don't remember forming the words. My aunt followed me toward the restroom. Laura stayed at the table. In the mirror, frosting clung to my eyelashes. My left eye would not open fully. When I tried, the pain sharpened and spread backward into my temple. My aunt turned on the sink and handed me paper towels dampened with cold water. I leaned forward and let gravity pull the icing away in small clumps. I could still hear the restaurant. Plates low, conversation, a server asking if we needed more bread. The world had not paused, but something in the room had shifted. 2 of my grandmother's friends had watched my sister push my face down. They had seen my eye close. They had seen that I was not laughing. I had filed an objection in probate court 3 weeks earlier. My grandmother's original will divided her estate evenly between Laura and me. A final amendment signed 6 months before she died left most of it to Laura as her primary caregiver. In my first affidavit, I had written that there was no significant family conflict. I had described my sister as devoted. I had told myself that restraint would look credible. Standing in that restroom with buttercream dissolving under cold water and my vision swimming on the left side, I understood that something about that sentence was no longer sustainable. Daniel knocked once on the door and asked if I could see. I said not clearly. He said he had recorded the moment on his phone because he thought it was just a birthday photo. He did not sound certain anymore. I was not thinking about court. I was thinking about whether I could drive home. The restaurant was 10 minutes from my apartment in northeast Minneapolis. I had planned to go back to work on Monday and answer emails about a project timeline. None of that felt immediate. The immediate fact was that my left eye was burning in a way that did not fade. We left before the check was settled. I signed it without reviewing the itemized receipt. Daniel drove because I could not trust my depth perception. I pressed a napkin to my eye and kept it closed against the streetlights. What I did not know yet was how this would matter. I only knew that something had happened in front of witnesses in a public room under my name. And whatever the truth of our family was, it was no longer something that could be described as uncomplicated. The probate notice arrived on Monday, February 26th, in a plain envelope from Hennepin County District Court. My grandmother had been gone 4 months. I assumed administration would be routine. The original 2018 will divided her estate equally between Laura and me. The amendment filed 6 months before her death did not. It named Laura as primary caregiver and shifted the majority of the home brokerage account and savings to her, leaving me a fixed bequest. The document was formally valid, signed, and notarized. It had already been admitted to the probate file by Laura's attorney. She had been appointed personal representative, which meant she controlled access to estate accounts during administration. If the amendment stood, she would receive the house outright and most of the investment portfolio. I would not. I met with a probate attorney that week. To challenge the amendment, I would need to allege undue influence, meaning the change was not the product of independent judgment. Caregiving alone was not enough. The court would examine control access and credibility. I filed a formal objection on March 1st. A week later, Laura's attorney disclosed the documents supporting her position, appointment calendars, pharmacy, receipts, photographs, and an affidavit describing her as the consistent day-to-day caregiver. None of it was fabricated. It was arranged to tell a single story. My name appeared once visited when her schedule allowed. An inventory followed. The financial imbalance was concrete. Legal fees would be paid from the estate during litigation. The longer the dispute lasted, the less would remain to divide. In my first affidavit, I described our relationship as generally respectful and free of significant conflict. I believed restraint would appear credible. At the time, the dispute existed only on paper. By the night of my birthday dinner, that description was no longer sustainable. The emergency room intake form stamped my arrival at 8:14 p.m. on Saturday, March 16th. Daniel had driven straight from the restaurant to Hennepin Healthcare. The entrance was busy but not chaotic. It was a weekend evening, which meant a steady line of patients but full staffing. I kept my left eye closed during triage because the overhead lights made the pain sharper. The nurse asked what happened. I said my face had been pushed into a cake and something hard had scratched my eye. She did not react to the family context. She typed foreign body to left eye, possible corneal abrasion into the intake screen and recorded the time of injury as approximately 7:25 p.m. My vital signs were taken. I signed the consent forms myself. Daniel remained in the waiting area until they called me back. When I tried to open my eye under the fluorescent lights of the exam room, tears came involuntarily. Not emotional tears, reflex. The physician's assistant irrigated my eye with saline and used fluorescein dye to check for scratches. Under the blue light, the abrasion was visible. She measured it and dictated her findings into the electronic record. Left corneal abrasion, no evidence of penetrating injury. She prescribed antibiotic drops and advised me not to wear contact lenses for at least a week. While we were driving there about 5 minutes from the restaurant, the pain had intensified suddenly. I had dialed 911 from the passenger seat because I was unsure whether the injury required immediate intervention beyond urgent care. The dispatcher confirmed our location and asked if I could see. I explained that I could not focus out of my left eye and that there had been trauma. The call lasted just under 3 minutes. An ambulance was offered. I declined because we were already close to the hospital. The dispatcher logged the call and cleared it as patient self-transport. I did not think about the log in that moment. I thought about the fact that my eye felt raw and exposed as if sand had been ground into it. At discharge, I received printed instructions with the timestamp 9:37 p.m. I signed acknowledging receipt of medication guidance and follow-up recommendations. The paperwork listed the diagnosis code. It also listed the mechanism of injury as assault by contact with foreign object, a standard phrasing chosen by medical staff when describing non-accidental contact. I noticed that line later, not in the hospital. Daniel asked if I wanted to file a police report. I said no. The injury had occurred at a dinner table. There had been witnesses, but I was not ready to escalate it into a criminal matter. I wanted my eye to stop burning. On Sunday morning, the swelling had reduced slightly, but my vision was still blurred. I called my primary care clinic to schedule a follow-up as instructed. The earliest ophthalmology referral appointment available was Wednesday afternoon. That meant 3 days of limited vision and antibiotic drops every 4 hours. On Monday, I emailed my supervisor at work explaining that I would be remote for part of the week due to an eye injury. I did not describe the cause. I attached the discharge note as documentation for HR. The note confirmed the date and diagnosis. That same afternoon, my attorney's office called to confirm a routine scheduling matter in the probate case. I did not mention the ER visit during that call. At that point, the cake incident and the estate dispute still existed in separate compartments in my mind. But the records did not exist separately. There was now a hospital chart with a time-stamped description of how my eye was injured. There was a dispatch log showing that I had called emergency services within minutes of the incident. There were witnesses who had seen the act in a public restaurant. Nothing about those documents changed the status of the will. The amendment remained in the court file. Laura remained personal representative. The caregiver narrative remained intact. What changed was that the conflict had moved beyond interpretation. There was a measurable injury documented by a third party with no stake in our inheritance. For the first time, the dispute had a physical record that did not rely on anyone's memory. I still believed the probate case would turn on signatures and medical capacity. I did not yet understand how credibility could intersect with something as ordinary as a birthday dinner, but the emergency record existed now, and it would not disappear. On Monday morning, March 18th, I emailed my attorney and asked for an in-person meeting. My eye was still sensitive to light, but I could read without closing one side of my face. The antibiotic drops had reduced the irritation enough that I could sit across a conference table and look at printed documents without tearing up. Daniel had already sent me the video file from his phone. He did not edit it. He forwarded the original clip with the embedded timestamp and metadata intact. I downloaded it directly from the link he provided and saved it without altering the file name. At 2 o'clock that afternoon, I sat in my attorney's office with a folder that contained 3 things: the ER discharge summary, the prescription receipt for the antibiotic drops, and a printout of the 911 call confirmation number I had requested from the city's public records portal that morning. The confirmation indicated that the dispatch record could be released in redacted form within 5 business days. We watched the video once. The clip was short. It began with Daniel lifting his phone to take a photo. Laura's hands were visible on my shoulders. There was no playful countdown, no warning. The motion downward was abrupt. My head struck the cake. There was a clear reaction from the table chairs, shifting voices rising. The frame cut off seconds later. My attorney did not comment on the humiliation of it. He focused on sequence and context. He asked whether there had been any prior physical contact that evening. There had not. He asked whether there were witnesses beyond family members. I confirmed that 2 of my grandmother's longtime friends were seated at the table and that restaurant staff had been present. He leaned back and said something measured this incident by itself would not invalidate a will amendment. Probate court does not punish birthday behavior. The standard remained undue influence at the time the amendment was signed. Then he shifted the frame. He pointed out that my first affidavit described the relationship between Laura and me as free of significant conflict. The video did not align with that description. Neither did a medical record that categorized the mechanism of injury as non-accidental contact. If opposing counsel chose to introduce the video, and they could once it was disclosed, it would be used to challenge my credibility for minimizing conflict under oath. Alternatively, if I withheld it and it surfaced later through another source, the omission would carry its own consequences. The question was not whether the cake incident proved undue influence. The question was whether my sworn statement still accurately reflected reality. He explained the procedural path. I could file an amended affidavit correcting the prior language. That would open me to cross-examination about why the change occurred after the dinner. It would also allow the court to consider a more complete description of the family dynamic. Amending a sworn statement is not a technical footnote. It becomes part of the record. It signals that something material was misstated or incomplete. I felt the narrowing of options in practical terms. If I left the affidavit untouched, the caregiver narrative remained largely uncontested in tone. If I corrected it, I would be admitting that my initial account was softened. That admission could be framed as instability or strategic adjustment. There was also the financial layer. The probate hearing was scheduled for mid-April. Discovery deadlines were approaching. Any amendment needed to be filed promptly to avoid procedural objections. My attorney asked a direct question: did I believe the statement about no significant conflict was still true? I did not answer immediately. The video was still open on the laptop screen, paused on the frame where my head had just lifted from the cake. He did not pressure me. He outlined the risk instead. Courts weigh credibility heavily in undue influence cases. A party who appears to shape testimony to fit convenience loses ground quickly. By the end of the meeting, we had not filed anything. We had set a follow-up for Wednesday after the ophthalmology appointment to give me time to consider the implications. When I left the office, nothing in the probate docket had changed. Laura remained personal representative. The amendment remained in the file. The caregiver story still stood. But the center of gravity had shifted. For the first time, the question was not simply whether Laura influenced our grandmother. It was whether I was willing to correct my own sworn record, knowing that doing so would permanently alter how I was seen in court and in my family. The decision had not yet been made. The path, however, was clear. On Wednesday, March 20th, after my ophthalmology follow-up confirmed the abrasion was healing, without complication, I drove directly to my attorney's office. The specialist had examined my eye under magnification and documented that the epithelial defect was closing as expected. He advised continuing the antibiotic drops for 3 more days. The visit generated a second medical note time-stamped and added to my patient portal by the end of the afternoon. I printed that note before I left the clinic. At 3:30, I sat across from my attorney again. The video file was on a flash drive in my bag. The ER discharge summary and the ophthalmology report were clipped together. The public records portal had updated that morning, confirming that the 911 dispatch log would be released in redacted form within 48 hours. He did not revisit whether the cake incident could invalidate the amendment. That question had already been addressed. Instead, he asked whether I was prepared to correct my prior affidavit. I had reread it twice the night before. The sentence stating there was no significant family conflict now read like a protective measure rather than an accurate description. It had been written before the dinner, but even then it had not captured the full strain beneath the surface. If I left it unchanged, opposing counsel could use the video and medical documentation to argue that I had misrepresented the relationship under oath. If I amended it, I would be admitting that my first statement was incomplete. Either path carried risk. We drafted the amended affidavit together. The document formally withdrew the language minimizing conflict and replaced it with a more precise description that tensions had existed regarding access to my grandmother's decision-making authority and financial transparency during the months leading up to the amendment. I stated that I had previously softened that description due to family pressure and a desire to avoid escalation. The amendment did not accuse Laura of assault. It did not request criminal charges. It attached the ER record as corroboration of the public incident and identified the existence of video evidence documenting the event. Before signing, I read the final version slowly. An amended affidavit becomes part of the permanent court file. It can be compared line by line with the original. It can be used to question consistency. I signed it anyway. The filing was submitted electronically that evening. The court system generated a confirmation notice with a timestamp of 5:12 p.m. Once filed, the document was accessible to opposing counsel. By the next morning, my attorney received an email from Laura's lawyer acknowledging receipt and indicating an intent to depose me regarding the change in testimony. The tone was formal. The implication was clear. At noon that day, my mother called. She said Laura had told the family I was rewriting history and escalating the dispute. She asked whether this was necessary. I did not argue. I explained that the affidavit needed to reflect what had occurred and that court proceedings rely on accuracy. The call ended without resolution. The practical consequences began immediately. A deposition date was proposed for early April. Additional document requests were issued seeking communications between Laura and me over the past year. My inbox filled with procedural emails. Nothing about the estate distribution changed that week. Laura remained personal representative. The amendment remained under review. No ruling had been issued, but the posture of the case had shifted. By correcting my sworn statement, I had removed the protective language that made the conflict appear minor. I had also placed my own credibility directly at issue. There was no return to the earlier version of events. The decision did not feel triumphant. It felt narrowing. For the first time, I was not simply responding to documents filed by Laura's side. I had altered the record myself, knowing that the cost would be measured in scrutiny, legal expense, and family strain. The conflict was no longer theoretical. It was documented in 2 affidavits bearing my signature. My deposition was scheduled for Tuesday, April 2nd at 9 in the morning in a conference suite rented by Laura's attorney in Bloomington. The setting was neutral. A long table, a court reporter at one end, a digital recorder running beside her laptop. Laura sat across from me with her counsel. My attorney sat to my right. There was no judge present. No ruling would be made that day. The purpose was testimony under oath. I was sworn in. The court reporter confirmed the spelling of my name and the date. The room felt procedural, not dramatic. Laura's attorney began with the affidavits. He established the timeline: original affidavit filed March 1st, amended affidavit filed March 20th. He asked whether I agreed that the language in the first affidavit stated there was no significant family conflict. I said yes. He then asked why that language had changed. I explained that the first affidavit had been written before the birthday dinner, and that even at that time it had understated ongoing tensions. I described pressure to avoid escalating family divisions. I acknowledged that the amended affidavit corrected that minimization. He asked whether the change was strategic, whether I realized that introducing the cake incident could cast Laura in a negative light before the court. I answered that the amendment was intended to align the record with observable facts and that the medical documentation existed independently of any probate strategy. He moved to the video. My attorney had formally disclosed the existence of the recording. Daniel had provided a sworn declaration confirming he recorded the clip in the ordinary course of taking a birthday photo and that the file had not been altered. That declaration had been exchanged in advance. The video was played on a monitor in the room. No one spoke while it ran. Laura's attorney asked whether I had provoked the action in any way, whether there had been joking beforehand, whether I had agreed to a birthday tradition. I answered each question directly. There had been no countdown, no consent, no prior physical play. He asked about my eye injury. I described the ER visit, the diagnosis of corneal abrasion, the follow-up appointment. He referenced the discharge summary, which had been produced through my medical authorization. The document was marked as an exhibit. At one point, he suggested that siblings sometimes engage in rough humor and that the injury might have been accidental. I stated that the motion in the video was downward and forceful, and that the medical record categorized the contact as non-accidental. Laura did not speak. She took notes. The deposition then shifted back to the months before the amendment. Questions about my grandmother's capacity, who attended appointments, who had access to bank statements. The caregiver narrative resurfaced now, interwoven with questions about whether I had felt excluded. I acknowledged that Laura had been present at more appointments. I also described a specific incident from the previous October when I had asked for copies of our grandmother's bank statements before a meeting at Wells Fargo. Laura told me they were already handled. When I later called the branch directly, I was informed that only the personal representative would be provided full access. At that point, the amendment had not yet been disclosed to me. I referenced other moments where appointment dates were shared after they occurred, not before. By the end of the 4-hour session, the amended affidavit had been tested line by line. The video had been played. The medical record had been marked as an exhibit. My explanation for correcting the record was preserved under oath. Laura's attorney indicated they were evaluating whether to challenge my credibility formally. No ruling was made that day, but the transcript would become part of the court file. For the first time, the caregiver narrative and the birthday incident existed in the same sworn record. The probate hearing was set for Monday, April 15th at 1:30 in the afternoon in a courtroom at the Hennepin County Government Center. It was not a jury trial. Probate matters in Minnesota are heard by a judge. The calendar that day included several estate cases, each allotted a defined window of time. Ours was scheduled for 90 minutes. Laura and I sat at separate tables with our attorneys. The courtroom was public, though only a few observers were present. Two of my grandmother's church friends sat quietly in the second row. My parents arrived just before the session began and chose seats along the side wall. When our case was called, the judge confirmed appearances and summarized the procedural posture objection to the amendment dated 6 months prior to death. Allegation of undue influence, amended affidavit filed by the objector, deposition transcripts submitted and exhibits exchanged. The judge had already reviewed the written submissions. That was clear from the first questions. Laura's attorney began by emphasizing the formal validity of the amendment. It had been signed, witnessed, and notarized. He outlined Laura's caregiving responsibilities and argued that increased inheritance reflected gratitude rather than coercion. My attorney did not start with the cake. He addressed the timeline of the amendment first. He highlighted the concentration of decision-making authority in Laura's hands during the final months of my grandmother's life, control over transportation management, of medications, access to financial statements. He referenced deposition excerpts in which I had described being told that certain matters were already handled. Only after that foundation was established did he move to credibility. The video was admitted as an exhibit through prior stipulation regarding authenticity. It was played without commentary. The courtroom was quiet in a different way than the deposition room had been. The judge watched the screen without visible reaction. The ER discharge summary and ophthalmology note were referenced, not dramatized. The purpose was not to argue that a birthday incident proved undue influence months earlier. It was to demonstrate a pattern of control and to challenge the image of a consistently measured caregiver. Laura's attorney objected to relevance. The judge overruled the objection, noting that credibility and relational dynamics could be considered when evaluating influence. Laura was called to testify briefly regarding the amendment. She described driving our grandmother to appointments, assisting with daily tasks, and being present when the amendment was discussed with counsel. She denied pressuring our grandmother. Under questioning from my attorney, she acknowledged that she had not informed me about the appointment at which the amendment was executed. She stated that she did not believe she was required to. The judge asked several direct questions. Who initiated contact with the drafting attorney? Who scheduled the appointment? Was independent counsel consulted regarding the shift from equal distribution to majority allocation? The answers were specific. Laura had contacted the attorney's office to confirm availability. The appointment had been scheduled during a week when I was traveling for work. No separate advisor had been engaged to review the change. The hearing did not feel dramatic. It felt methodical. By the time arguments concluded the issue before the court had narrowed. The question was whether the amendment represented my grandmother's independent intent, or whether the circumstances surrounding its execution raised sufficient concern about undue influence. The cake incident was not framed as punishment. No criminal charges were discussed. It existed in the record as one data point among many relevant to credibility. The judge did not rule from the bench. He stated that a written order would issue within 30 days. When we left the courtroom, nothing had been reversed. The amendment remained in effect pending the court's decision. Laura remained personal representative. But the narrative had shifted from a simple caregiving story to a contested pattern of access control and credibility, all documented in the court record. For the first time, the evaluation was no longer confined to filings and depositions. It rested with a judge who had seen the full sequence. The outcome was not yet known. The record, however, was complete. The court's written order was filed on Thursday, May 9th at 10:17 a.m., according to the timestamp in the electronic docket. I saw the notification on my phone while I was at my desk at work. The subject line from my attorney's office read simply, "Order issued." I did not open it immediately. I stepped into an empty conference room before clicking the attachment. The document was 8 pages long. The first section summarized the procedural history. The original will from 2018, the amendment executed 6 months prior to my grandmother's death, my objection alleging undue influence. the amended affidavit, the deposition testimony, and the exhibits admitted at the April hearing. The judge then moved into findings of fact. He acknowledged that the amendment met formal execution requirements. It was signed and notarized. That point had never been in dispute, but he focused on circumstances surrounding its creation. The order noted that Laura had arranged the appointment with the drafting attorney, that the appointment occurred during a period when she had primary control over transportation and scheduling, and that no independent advisor had been consulted regarding the significant change in distribution. The judge addressed credibility directly. He referenced inconsistencies between Laura's portrayal of a consistently measured caregiving relationship and the documented incident at the birthday dinner. He did not describe the event in emotional terms. He referred to it as recorded physical contact inconsistent with the objector's initial affidavit description of relational harmony. He also addressed my amended affidavit. The order stated that while the change in my testimony required scrutiny, the explanation for the amendment family pressure and a desire to minimize conflict was supported by the timing of the filings and by corroborating evidence in the record. The conclusion was clear. The court found that the totality of circumstances raised sufficient concern regarding undue influence in the execution of the amendment. The amendment was declared invalid. The estate was to be administered and distributed pursuant to the original 2018 will. There were no punitive damages, no sanctions related to the cake incident, no criminal referrals. The decision was confined to probate authority. The practical effect, however, was immediate. Laura's anticipated majority share was no longer enforceable. As personal representative, she remained responsible for completing administration, but distribution would follow the equal division outlined in the original will. The brokerage account and the house equity would be split evenly. Later that afternoon, Laura's attorney filed a short notice indicating they were reviewing the order for potential appeal. The filing did not stay the decision automatically. Absent a granted motion, administration would proceed under the court's ruling. My attorney called to explain next steps, updated accounting, proposed distribution schedule, and the requirement that Laura, as personal representative, comply with the order unless an appellate court intervened. At dinner that night, my parents were quiet. No one raised their voice. The shift did not feel like victory. It felt final. Laura did not contact me directly. The ruling did not repair our relationship. It did not erase the deposition transcript or the video file. It did not undo months of strain. What it did was reset the estate to the structure my grandmother had chosen years earlier. The majority share Laura had expected was no longer hers by court order. The amendment she had relied upon was removed from legal effect. The power dynamic in the case had changed, but the cost of that change was visible in every room where our family gathered. By early June, no appeal had been filed. Under Minnesota procedure, the deadline to appeal the probate order passed without a stay. Laura's attorney submitted a short notice to the court, confirming that the estate would proceed under the May 9th ruling. The practical work of administration resumed in a different tone. An updated accounting was filed. The brokerage account was partially liquidated for taxes and expenses. The Bloomington house was listed sold within 6 weeks, and the net proceeds deposited into the estate account. As personal representative, Laura executed the required documents in compliance with the court's order. In July, I received a wire transfer representing my half of the net estate after expenses. The amount matched the court-approved accounting. I reviewed the numbers line by line before signing the receipt acknowledging distribution. No one announced closure. It appeared as deposits and filed confirmations. The cake incident was never prosecuted. No charges were filed. The 911 log remained a record of a call cleared as self-transport. The ER chart remained in my medical history. The corneal abrasion healed fully confirmed at my final follow-up in late March. There was no permanent damage. The amendment that once redirected most of my grandmother's estate to Laura no longer had legal effect. It remained in the file as a document declared invalid. Our relationship did not return to what it had been. At family gatherings, conversation became logistical rather than personal. I limited communication with Laura to written messages about estate matters until administration was formally closed. After the court approved the final report in August and discharged her as personal representative, there was no longer a legal reason for regular contact. I changed how I handled access. I requested copies of all estate filings directly from the court rather than relying on family updates. I set clear boundaries about discussing finances in group settings. I declined invitations framed as clearing the air. At work, I used part of the distribution to pay down my student loans and set aside a reserve fund. I did not describe it as winning. I described it as aligning with what had been written years earlier. The most permanent shift was not financial. It was that my sworn record now matched what had occurred. The amended affidavit remained in the docket. The deposition transcript existed. The written order detailed the court's reasoning. None of it depended on who told the story at Thanksgiving. The inheritance was divided as originally intended. The amendment was set aside. The probate case was closed. The cost was a narrower family circle and a clearer line around what I would and would not minimize in writing again. If you have ever corrected your own sworn words, knowing it might cost you something, you understand that justice is not loud. It is documented.
This story is creative content developed for storytelling and reflection. It does not depict any specific real individual